Good afternoon, wherever you are in the world. Hopefully, you can all see and hear me. Can you give me a 5v5 in the chat if you can see and hear me? Let me have a quick look and see what's going on there. So let me see if you can see me and hear me. Can you hear me? Give me a 5v5 in the chat. Hopefully, it's going out to everywhere that it's going out to. 5v5 coming up. Okay. There's quite a bit, well, not quite a bit I'm going to cover, but I'm going to be concentrating on a few things. First of all, I'm going to ask the audience, there's a couple of things I'm going to cover off first, and then I'm going to get stuck into the Constitution. And literally, and this is not a photograph, this is actually from the book that's in front of me. So I'm hoping it's going to come up on your screen, right? So just to show you, I mean, literally, that is the Housery Laws of England, Volume 8, and it's in reference to the Crown in relation to the law. Now, I'm going to go through quite a bit of this tonight because I think it's important that people see the different elements where it's again referring to the coronation oath and by the maxims of common law. And so it says also the ancient charters, which means, and again, I'll take you some other bits where it says the Magna Carta, but it's all the charters and all of the statutes to protect the liberties of the subject, which is the part that I'm showing you there, right? And statutes confirming the liberties of the subject. So what I'm trying to get over to you tonight, in a very big way, that you understand that we are under occupation by the only thing I can describe it as is the Soviet regime, right? That is completely ignoring our constitution because it chooses to, and that they have put people in place in the judiciary and barristers and solicitors that are completely ignoring our constitution, including the king, I may add. You can make references to the English Bill of Rights where it says, in effect, that he was being counselled by evil people. That said, there's enough known in history for him to understand what is. That's why I don't. Anyone who says to me, let me go back to that. Anyone who tries to say to me that the king's been captured, I'm not interested in that. And even if he has, without saying too much, I know people who have been captured and tortured, and they're still 100% would die for this country. So anyone that says any of that nonsense in the background, I'm not listening to it. Right? You betray this country, you commit treason. If you're the King of England, the only thing the Magna Carta says is we can't harm you or your family, but we can take back from you everything that you possess, including the castles, including the crown jewels, which belong to us, the people, anyway. That was already factual from resmelting the crown and stamping in it the property of the Commonwealth, meaning the people. So again, I'm gonna come back to this because I think it's really important that people understand it. But before I do, there's a couple of items I want to show you. Pretty classic, I should imagine. But the first is, and we're going to go and have a look, hopefully, if I can find it again. And this always happens. I actually put things in there so I can see it, and then it goes pear-shaped. Right, let's have a look. I'll have to go to Rupert Lowe. Because did everyone see what he put out today? I think it's important that people see this because it's crucial. Crucially important. So there's a 10-minute, and then there's another one which is 23 seconds. But I'm going to show you this one first because I think it's the most important. Anyone can go and see this. Anyone can pick it up on Twitter. I've no doubt he's on Facebook, etc. But people really do need to understand what this is about, right? So again, it's self-explanatory. I don't need to say that much about it or talk through it, because everyone should understand. There was 720,772 people that signed this petition. So he is talking on behalf of them people, and there's just a handful of MPs in there, right? One way or the other, we know that we have to get rid of these MPs. I think there's something seriously going on in the background. I don't think they're panicking. I think they're implementing a plan. And I think that is part of what we're seeing with Anne Whitcomb. It's part of what we're seeing. They've just made a number of arrests in England, reference to far right terrorists. I think we're seeing them implementing their plan, and that's why they're putting Andy Burnham in place. But what I'm going to do now is show you this.
772 British men and women who signed our petition demanding the mass deportation of illegal migrants. A policy position that has moved from the so-called mad fringe to the acceptable mainstream in less than 2 years. But the question is no longer whether Britain has a problem. We know the problem. It's been well documented. Now we need solutions. Restore Britain is the first and only political party to publish a comprehensive plan, not just to stop future illegal immigration, but to remove those who have no legal right to remain in this country. All of them, every man, woman, and child. They must all be deported, and a Restore Britain government will do exactly that. I'm not going to stand here and outline the problem. We all know what's wrong. I'm going to tell this Parliament exactly how we can remove millions of illegal migrants. As we have seen time and time again, deportation is routinely frustrated by a carefully designed maze of legislation, international treaties, and legal challenges. A Restore Britain government will repeal or amend the domestic legislation that prevents swift deportation, repeal the Human Rights Act, withdraw from the European Convention on Human Rights, and remove the Refugee Convention from domestic immigration law. It would also introduce what we call the Great Clarification Act, reaffirming that we in Parliament, in these buildings, have the final say over immigration policy, allowing Parliament to overturn court rulings that obstruct the democratic will on immigration. Not activist judges, but elected politicians, held to account by the British electorate. But legal reform is just the start. That simply sets the scene for the most ambitious set of deportations ever seen. The real question is this: how can we remove all of those with no legal right to be in Britain? The answer is by making illegal residence impossible to sustain, as we call it, the hostile environment. No legal employment, no legal tenancy, no access to public services, no banking facilities. That single reform becomes the backbone of our immigration enforcement. Make life so incredibly uncomfortable and unsustainable that many will simply deport themselves. Employers must face real-time right-to-work checks. The gig economy, construction, hospitality and other sectors with persistent illegal working would face regular audits. If Uber Eats, Deliveroo and the rest are found to be employing illegal migrants, they will be fined, prosecuted and even shut down. The farce of young Sudanese illegal migrant men delivering spring rolls and pepperoni pizzas on mopeds in every British suburb will end. Government itself must lead by example. Every company bidding for public contracts would have to demonstrate strict compliance with immigration law before receiving any taxpayers' money. ESG, but for mass deportations. Housing enforcement would change completely. Every landlord would be required to carry out right-to-rent checks at the beginning of every tenancy. Those who knowingly rent properties to illegal migrants would face severe financial penalties, and persistent offenders could face asset seizure and prosecution. HMO owners who impose gangs of feral illegal men on quiet British villages will be prosecuted. Public officials who knowingly place dangerous and unvetted migrants near schools and nurseries will be sent to prison. Homelessness legislation must also be amended so that illegal migrants are no longer recycled through local authority housing systems, but instead enter the immigration enforcement process. We will not house illegal migrant tramps, we will deport them. It's really that simple. Healthcare would no longer operate as a loophole. So-called safe surgeries must end. Proof of lawful status must become a requirement for routine NHS access. Illegal migrants in hospitals will, as they should now be, reported to immigration enforcement. We are not evil. Emergency care will be provided, but they will be then deported as soon as it's medically safe to do so. Across government departments, the departments will finally begin sharing data. The Home Office, HMRC, the NHS, local councils, the DWP, banks. Instead of operating in silos, government will work as one system to identify those with no legal right to remain. The full power of the British state will be directed to implement this one policy, mass deportation. Financial enforcement would become another powerful tool. Banks would verify immigration status before accounts are opened. Existing accounts without lawful status will be frozen or closed. The hostile environment measures will force out hundreds of thousands. A concurrent program of enforced deportations will be implemented alongside this to remove the rest. Restore Britain proposes a major expansion of immigration enforcement, recruiting thousands of additional officers, drawing on former police officers, military veterans, and experienced investigators. A specified recruitment campaign for military veterans will be implemented, drawing former soldiers into field enforcement roles. Detention capacity would be expanded dramatically, including the use of purpose-built detention facilities capable of holding thousands awaiting removal. Commercial airlines will continue to be used where appropriate. Dedicated charter flights would become routine. Military transport aircraft would also be available where operationally necessary. Time will not be wasted. Specialist detention facilities will be constructed near airfields to hasten the process. Britain will negotiate far stronger bilateral return agreements while working with allies to create a deportation NATO, a coalition of like-minded countries applying coordinated diplomatic and economic pressure on governments that refuse to accept back their own citizens. Harmonized visa sanctions, coordinated suspension of visa issuance, foreign aid suspension, targeted trade measures and tariffs, remittance and dividend controls and taxation, rapid response returns task force. Pakistan would be the first country to feel the full force of these measures. Sanctions from a single country are easier to absorb, but a unified bloc of economies and travel markets creates systematic and severe pressure. Coordinated restrictions would also close loopholes, whereby nationals bypass one state's measures by moving to another jurisdiction, all delivered alongside the credible and proven threat of action. Do it once hard enough, and it wouldn't be required again. We must also revoke all asylum grants awarded following illegal entry and retrospectively revoke protection so that those individuals are also removed. If you arrive in Britain illegally on a small boat, you will be deported, regardless of what your current status may claim. People ask whether this is achievable. Restore Britain says yes, but only if government finally demonstrates the robust political will required. What about cost? Britain is already paying billions every year on accommodation, billions on asylum, billions on public services for illegal migrants, billions supporting people who have no legal entitlement to remain here. In the short term, ending those long-term costs will offset the expenditure required to carry out removals, with estimated annual savings of more than £12 billion once the programme is complete. Put simply, mass deportation pays for itself. It's popular, it's cost-effective, and it's possible. I have just one question for my fellow MPs. What are we all waiting for? This is a costed, comprehensive, and legally sound plan that will, as those 720,772 British patriots demand, remove the illegal migrant population. We have outlined exactly what needs to happen in excruciating detail. It can be done, it must be done, it will be done. On your way out, please help yourselves to a mass deportation policy document. It makes glorious reading. Thank you. Firstly,
it makes glorious reading. And I've read that document, by the way. There's things I would add, but I'm not going to get in. No, to me, constitutional elements to it. Again, I'm going to take you back to this one. And then we've got a couple of other quick videos to watch, which are really important. Then I'm going to get on with the constitutional elements. Now, this person is someone called Paul Weston. And his comments are, who is saying it was a credible threat? Home Secretary. This is in relation to these people who have been arrested today, and over the weekend. Credible threat, Home Secretary. The Pakistani Muslim, you, or the Pakistani Muslim mayor in charge of the Sharia-compliant London Metropolitan Police. All right, he's got a valid point here. So again, not sure how much of that's in there, but
this weekend, an event in Suffolk was due to be attended by over 10,000 Muslims. Instead, it ended early because the police had become aware of a credible threat to the lives of those present. They acted with speed and skill, and I thank Suffolk Police, counter-terrorism policing, and the organisers for their swift and effective response. Thanks to their actions, those attending the UK Ijtima in Barham were kept safe. 12 individuals have now been arrested as part of an investigation led by counter-terrorism police, which they describe as extreme right-wing terrorism related. This investigation is at an early stage, and we must give them space to pursue their lines of inquiry, and I know the police will provide further updates. But let me say, we must all stand united against hatred. The actions of a minority are not who we really are as a country, and we should never be defined by those who plot violence against their fellow countrymen and women.
Well, so again, I am actually going to try and find you a report from the police, the Metropolitan Police, but not one of the men arrested was at the Muslim event. In what possible way can this be seen as a credible threat? This is a Soviet-esque non-crime to be followed by a Stalinist show trial. Zelensky wrote extensively about this, and he did. He also lamented not killing the Cheka or NKVD agents who arrested innocent men at dawn in Bolshevik Russia. My reply to Paul was, we are living under occupation, and we are under occupation. The police, whether they be MI5, whether they be anti-terror police, whether they be the normal police plod out on the street, are now part of the Red Guard. It is my opinion that the only people that can assist with the organisation of a resistance are highly skilled military veterans who know exactly, and there are quite a few that I've spoke to, don't know exactly what's going on. I am going to say a couple of there's things I want to say and I can't say for various reasons, not least of which I can tell you now that everyone, these communists are talking about universal basic income. What is that? Well, another word for a universal basic income is a pension. And what you'll see is a lot of these people are doing exactly as they're told for their pensions. But once you are in any position and retired, if you see what's going on and you don't stand up, 9 out of 10 times the reason for that is because they can take your pension at any time. So they are showing control of people, individuals, whoever they are, whether they be ex-police officers, whether they be ex-veterans or not ex-veterans, but veterans, etc. But that is what's going on. But Paul Weston says here, we really are, in reply to my comment, we are under occupation. Few understand how bad this will become. It's time to organise a resistance movement, right? We should have been doing this a long time ago. And there's certainly some people out there, I'm not going to mention any names, that keep saying to us, don't talk, if you start talking about a civil war. This isn't a civil war situation. We are under occupation. We need a resistance, and we need to be organised. The problem is the British have control of all communication. They have control of the money. Let's say they take away your money tomorrow and you've got nowhere to live because that's what's paying your rent. You're automatically homeless. You're automatically without food, and you're literally homeless and starving. Right? The only people they're assisting are the invaders via what they're describing as tax money. But in reply to Paul Weston, I watched a video by someone called Major Alex Watts. I don't know him. I don't know whether he's to be trusted, but I thought it was a good video. I only watched it this morning. He has been on the Mike Graham show a few times, but Army veteran warns Britain is being pushed towards, and he talks about civil war. He's got to understand that this is a resistance movement, and it's got to be organised. It's got to be distributed, because if it isn't a distributed movement and people keep bringing people into London, you're coming to where the enemy has full control. It would be no different to everyone turning up in Manchester. Again, the Fabian Society have got full control, and they've now started moving the administrative elements of government into Manchester. And Manchester was one of the major early settlements, if you want to call it that, of the Fabian Society. In other words, they have complete control up there, which is why Andy Burnham is moving the Fabian Society from, in effect, government from London to Manchester. So there are lots of things going on. Now, something I want to show you now is this. I'm going to bring it up on the screen and hopefully everyone will watch it again. Right. Now, I keep telling people that the United States of America, and this is just one video, United States of America, and again, thank you for Jason for sending it to me, are taking back the United States of America constitutionally, right? There are many things that they're doing. There are a number of cases where they are referencing the Bill of Rights and the original Bill of Rights and the original meaning of the Bill of Rights. They have mentioned where it comes from, meaning England, right? i.e., they understand it is not British, it is English, and they are talking about the common law, the Constitution, and the Supreme Court in America. You can use their judgments, as long as it's come, and there's nothing more powerful than a 9-0. And there has been a couple of them in some other cases, which I'm not going to show you tonight, but they are really important. And I've been keeping an eye with assistance from other people, and especially some great American people, to keep an eye on these cases, because we can use them in the High Court in London with reference to what's going on in the background. So I'm going to let you listen to this, and then we're going to start talking about our Constitution, because it's where the American Constitution comes from.
The Supreme Court has just stepped directly into a massive constitutional clash that could completely upend how the criminal justice system operates in some states. If you think that your right to a fair trial is completely safe under the Bill of Rights, you need to watch out, because the High Court just granted review in a case that exposes how the government has been shortcoming your fundamental constitutional protections. Recently, the Supreme Court agreed to take up a fast-moving challenge known as Keon versus the state of Florida. And on paper, this started as a local dispute involving a state licensing case, but now it has become a question of what the founders of our country actually meant when they talked about your right to a jury. Currently, 6 different states have been actively bypassing the traditional 12-person jury requirement, convicting individuals using that shrunken 6-person jury instead of the 12. The current conservative majority of the Supreme Court just signaled that they are ready to completely tear down that loophole, but the fallout from that upcoming ruling is going to trigger a shockwave that impacts all Americans. So we need to break down what is now happening in this critical case. Now, before we jump into what the Supreme Court just did, if you like this type of content, make sure you subscribe and turn on all notifications to ensure you never miss this information when I release it. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. So if you're interested, you can check them out using the links down $5 off the Supreme Court. So in this case, the petitioner is a Florida resident. Here he was charged by the state and state prosecutors with multiple felony counts of practicing chiropractic medicine with a suspended license. Now, under normal circumstances in a federal court, if you face serious prison time, you are guaranteed a traditional and robust 12-person jury to stand between you and the power of the state. But Florida, along with 5 other states, including Arizona, Connecticut, Indiana, Massachusetts, and Utah, have exceptions. For non-capital offenses, they shrunk your constitutional shield down to just 6-person juries. So in this case, Mr. Keon was forced into a trial before a shrunken 6-person panel. He was convicted and sentenced to over a year in prison, followed by 5 years of probation. Now, Mr. Keon fought back, demanding that the 6th Amendment right to a full 12-person jury was violated. The state appeals court outright rejected his arguments, pointing to a 1970s Supreme Court precedent called Williams versus Florida. So that's where that precedent comes from. So in that older ruling, in that past Supreme Court case, the Supreme Court had used an analysis which really was a cost-benefit analysis. And they claimed that a shrunken 6-person jury could be equally effective as a traditional one. But Mr. Keon's legal team did not accept that, so they brought this case in front of the Supreme Court. And they argue that the era of watering down the Bill of Rights is officially over. In this case, he argues that Supreme Court precedent has now changed since that prior ruling, and the court should now officially overrule their prior precedent. And now the Supreme Court has granted review to this critical case. But the question is, why did the Supreme Court now suddenly grant review to this issue? Well, that is because Keon's petition completely corners the Supreme Court using their own modern logic in some new cases. In this petition for review, Mr. Keon pointed out directly to a massive landmark victory from a 2020 case called Ramos versus Louisiana. In that case, the Supreme Court completely struck down non-unanimous jury verdicts, ruling that the 6th Amendment must be interpreted exactly as it was understood when the Bill of Rights was adopted back in 1791. The Supreme Court in Ramos...
Do you understand what's going on here? This is called originalist. This is how we interpret the English Bill of Rights as well. That's how Lord Denning interpreted the English Bill of Rights. Sir John Laws interpreted the English Bill of Rights. In effect, Sir Stephen Sedley interpreted the English Bill of Rights, and most lawyers or judges that understand and have read it, and the original I'm talking about, right? That's why it was more important in reference to Lord Denning, and I want to come back to that.
Explicitly rejected the exact kind of cost-benefit analysis that was used in the 1970s prior case. Also in his petition, Mr. Kian's argument goes back to the originalist concepts and focuses on the intent of the founders. He argues that at the founding of this country, the word jury meant one thing and one thing only: 12 ordinary citizens that are reviewing your case. When the people enshrined that right, they did not attach a rider or an exception, allowing future state bureaucrats to downsize it to save time and money. Now, also to show how confident Mr. Kian's legal team is in this originalist argument, they just filed a brand new motion asking for the Supreme Court to completely dispense with the requirement of a joint appendix. They told the Supreme Court that this is a pure question of law, meaning that the facts of the local arrest do not matter at all. The lower court's opinion was completely unreasoned, and there is zero need to waste time or money compiling a massive mountain of lower court records, looking at the facts of this individual case. Also, Florida isn't even opposing that request. By dropping the filing, Kian here is stripping away all of the administrative noise and forcing the Supreme Court to look strictly at one thing. Does the Constitution mean what it says when it guarantees a jury trial? Now, this is where this case applies to all Americans, especially you as a gun owner. So think about this. If the government is allowed to prosecute complex, high-stakes Second Amendment cases or technical compliance violations before a shrunken six-person jury, it becomes drastically easier to secure a conviction. It takes far less effort for the state to manipulate or pressure 6 people than it does to convince 12. Also, this impacts your fundamental rights as an American by watering down what protections the founders actually intended in the Sixth Amendment. Now, in this case, the Florida Attorney General desperately tried to stop the Supreme Court from taking the case. In their brief, they wrote an opposition, and the state openly admitted that if the Supreme Court overrules this old loophole, this 50-year loophole, it would instantly imperil thousands of active criminal convictions in Florida and also the 5 other states. The government is worried because if the Supreme Court overrides their prior precedent, it opens the door to new challenges and challenges also to current cases that have been ongoing using those 6-person juries. So make no mistake, by granting review, the Supreme Court's conservative majority has signaled a massive potential change on a critical constitutional right. They are poised to declare that states cannot alter, shrink, or dilute the literal text of the Bill of Rights under the guise of administrative convenience or time saving or cost savings. The constitutional shield of a 12-person jury is on the verge of a total nationwide restoration, but until then, it's going to be a legal minefield for all of these 6 states that are using the shrunken jury in these types of cases, and there's going to be questions about, is that constitutional going forward? So that is the critical case that the Supreme Court recently granted review on. The loophole has been challenged, and the government is officially panicking because this case was granted review. I will be tracking this case as it moves forward, but we've already got some interesting developments, and we kind of got a glimpse to the position of the petitioner here, of Mr. Kian, and the confidence he has in his argument. So as it develops more, as we get more information, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, subscribe, and also turn on all notifications to ensure you never miss these videos when I release them. But as always, thank you so much for all of your support, and never forget, this nation was...
Right, so just to make sure everyone's aware of this before I go any further, you may or may not think that the largest common law jurisdiction in the world, the United States of America, and I want everyone to remember this, don't listen to any nonsense about it Americanizing is England, right? We anglicized America. We exported the common law. we exported our language and we exported our constitution, and it is being applied currently correctly. And this case is really important when people start looking at juries and what the Fabian Society have gradually done. And when I say gradually, one of the things that does frustrate me, right, does frustrate me about Restore Britain is that they're referencing only what Tony Blair has done. There were other Fabian prime ministers, namely Clement Attlee, and I'll bring it up on the screen if anyone wants to see it. But Clement Attlee was his government and technically his parliament that removed the protections of the Acts of Settlement using Schedule 4, which is in this law book I've got in front of me. It was him that privatised the Bank of England, bringing it under Fabian control. So everyone's out there saying all these different things about the Bank of England. Remember, it was originally created by a Scot, right, William Paterson, in 1694. That said, and you understand the principle that I'm talking about, Clement Attlee then, by stealth, removed sections of Part 2 of the English Bill of Rights. So the English Bill of Rights, there was a Section 1 all the way through, there was a Section 2, and there was a Section 3. Section 3 was removed in 1858, right? It should never have been touched. It protected all our ancient charters and customs. Section 2 was a particular paragraph that was top and tailed by this Clement Attlee government. And it was the paragraph that basically said, in no uncertain terms, that Parliament is not sovereign, that we are protected by the Bill of Rights and it can be never be changed. It could only be changed during the Convention Parliament. Yet the subtle changes that have happened outside of that Convention Parliament, right, when it was strictly forbidden, are what's now affecting particularly the English. And we need to understand what our Constitution is and how it protects us, right? So again, what I'm going to do now is I want everyone to understand, please don't be one of these people who start slagging off America and Americans, right? All you're doing is regurgitating the psychological reframing of the British, right? By doing that. We anglicised the United States of America. They continued with the tradition of common law and the Constitution of England. To such an extent, it is the freest nation in the world, or was, right? Until some of these things come in. Now they're bringing back the full Comanche juries again, saying you're not getting away with this. And people need to understand that grand juries in England were abolished by the British. And again, the Fabians had a hand in that. So when I say I am frustrated at Restore Britain, they are not looking at the deepness and the it's not just the depth, it is the multi-generational conspiracy of this group of people to destroy England, because England is the beating heart of the United States of America. It is the beating heart of the common law jurisdictions. That's why they've gone to attack South Africa. They attacked all these different places all around the world. New Zealand, Canada, Australia. Any common law jurisdiction has been and is being attacked. And the only place that is fighting back is the United States of America. The difference with the United States of America is that they do not have a strict monopoly on constitutional barristers presenting cases for the people, which we have here, right? The only person that is presenting constitutional cases from the point of view of a subject of the realm of England is me, as a subject of the realm of England. And what I try to teach you, because you're the people who need to understand this, is exactly, there's so much of our constitution, but you can literally pick it up from 2 or 3 books, right? But what I'm going to do is show you this again because I think it's important. So again, this is Halsby's Laws of England, right? It's an actual law book. It isn't some nonsense I've made up, and it's not me interpreting it in any other way. I'm just showing you what it says. And this again is Volume 8 Constitutional Law, and it is paragraph 943. So this is the Halsby's Laws of England, Volume 8 Constitutional Law. It's the 4th edition, and it's saying paragraph 943, and this is what it says: the Crown as the source of all jurisdiction, sovereign as the source of justice. By virtue of the prerogative, the sovereign is the source and fountain of justice, and all jurisdiction is derived from her. Hence, in legal contemplation, the sovereign majesty is deemed always to be present in court, right? So when you bow in court, you are bowing to the crown, to the monarch, to the majesty of our laws, not to the person. It's a bit like saluting an officer, right? You're not bowing to the person in robes and with a wig on. You're bowing to what they represent, because they are a crown servant and administering the monarch's justice, right? It's really important that people understand that. And by the terms of the coronation oath and by the maxims of the common law. So just have a look at what that says again, right? So majesty always to be present in court, and by the terms of the coronation oath and by the maxims of the common law. Now again, the Coronation Oath Act was created in 1688 by a convention parliament, and it wasn't allowed to be changed, right? And by the maxim of the common law, so it's agreeing that the common law is by force of law, the law of the land, and also by the ancient charters, meaning Magna Carta, Charter of Liberties, Charter of the Forest, and there's a whole group of them, right? And it's not just ancient charters that are reference to the people's rights. It's the ancient charters that cover the cities, right? So people need to understand that. And statutes confirming the liberties of the subject, right? So one of the things that I wanted to show you, which again I haven't got it at the moment, but there's a red book on the bottom of that pile there, that one there, right? It's really important that people understand what the Bill of Rights did and what its preamble was and what the long title stated completely, right? Now I've brought it up. No, not that one, that red one there. I've brought it up before, and I'm just going to get this out and read it to you, which is the Bill of Rights and what it says. Hopefully I can find it straight away. Where's the Bill of Rights? Coronation Oath Act, Corporation Act, statutes, right? And let me go through this. Convertible Act of Uniformity. Declaration, right? I can't find that straight off. It's not triggered enough. Hang on, let's see if I can get this because it's important. Right, here's the Bill of Rights. And it says this, right? So just in case you want to see it, I'll bring it up. Don't forget, this is the original. This is the original, right? It's not bullshit. It's original in its context, right? So I'm gonna bring that down just to make sure that you can read this on the screen, right? So what you see online is not the original Bill of Rights, right? So again, Bill of Rights, and before that you had the Declaration, an act declaring the rights and liberties of the subject and settling the succession of the crown. So it done two things. It settled the succession of the crown, but it was declaring the rights and liberties of the subject. This is really important, right? Now, again, if I was to go back to this, and then we're going to go back, I'm going to show you section 2 again and what they took off, which they wasn't allowed to do. Right, so section 2 is there. I'll come back. So again, read what it says on here. Right, again, this is a law book. This isn't me saying it. And statutes confirming the liberties of the subject. Right, now remember what the Bill of Rights just said to you of what it actually is. It was declaring the rights of the subject. Right, and then there's another element to this which needs to be shown to you yet again, which is this part here. Right, this is the Bill of Rights, and it be further declared and enacted by the authority aforesaid that from and after this present session of Parliament, no dispensation or non-obstante of or any statute or any part thereof, that means the Coronation Oath Act, that means the Bill of Rights, right, thereof, shall be allowed, but the same shall be held void and of no effect, except a dispensation to be allowed of in such statute, and except in such cases as shall be specially provided for by one or more bills or bills to be passed during this present session of Parliament, which was the Convention Parliament, right? So most importantly, what you can't see here, right, which I'm going to try and see if I can, I don't want to, if I want to rip that off or not, but let's see if I can do this with a couple of envelopes. Like I say, I don't normally use props or anything, but what they in fact did, right, was they by stealth, they didn't tell us, right? They moved part of that, they took out part of that, and they took out part of that, right? And so they top and tailed it, which I've shown on a full document, which they wasn't allowed to do, right? And they've made themselves so it appears that they can change any law they like. They cannot change the Bill of Rights, right? But that's what they've been doing. And they've been making laws that go against the Bill of Rights, right? And then saying they're allowed to do it, which they clearly are not allowed to do it, right? So I'm going to go back to this one because it's important that everyone sees this one. So I'm going to come back up here and show you this one. This is where hopefully we'll get back onto that one, right? Paragraph 9.4. Be hearing me again. Let's have a look. Right, can you all see and hear me again? Give me a 5p5 because it probably, and I can tell people at the moment there are things going on in the background with the government and me, right, and other things, but we have to be careful. Give me a 5p5 and I'm back. They definitely do not like me showing people this, right? They don't like me keying into what's going on in the US, and they don't like me presenting this to people and actually educating people on what our rights are, right? So writs and legal process, all writs run in the sovereign's name and are executed by officers of the Crown, and all judges and magistrates are appointed by and derive their authority either immediately or immediately from the Crown. They must, however, exercise their authority in a lawful manner, right? A lawful manner. So if you're telling them there's a Bill of Rights and that's what it says, they're supposed to be listening to you without deviating from the known and stated forms. Now, the known and stated form is the English Bill of Rights and the Coronation Oath Act and the Declaration of Rights and the Magna Carta and the Charter of Rights, because it's all protected, right? The laws are the birthright of the people, and the sovereign neither has power to change them apart from Parliament, right? But I'm going to show you what it says in the next part of this, which is really, really important. Let me have a look and see if I can find it straight off here. There's the estoppel part I just found in there. The estoppel is the Crown is not bound by fiction of law. It may possibly take advantage of estoppel by deed, though not, it seems, where the estoppel arises through its own letters patent, right? So let me just make sure. I'll come back to this because there's another element to it. Again, I've got to go and find it for you. So let me go back to this. Does everyone understand what I'm actually trying to get at here? They've been lying to us in quite a big way. There's that one. There's the sovereign. There's some other elements of the sovereignty, which I'm going to get to now, that people need to fully grasp. So the sovereign head of the Grace is not associated with two houses of Parliament. But look, convention in the exercise of the powers exceptional cooperation. Let me just make sure I've got this. Separation of executive. Again, this tells you that no one can do as they like. Like the king can't do as like, but nor can the Parliament either. It is restricted in the way that it operates. And what I'm going to do now is show you something else. And no wonder I didn't have that because it's not there. Right, I need to put in one of my markers again. That's why I couldn't find it. If I put in foreign ascendancy, right, so really important. Right, I'm going to show you what it says in here, right? And foreign ascendancy is in here as well. Right, so let me show you this. Hopefully you can see this properly, right? Let's see if I can get that down a bit further. It is hard getting this set up properly. Right. Subjection to the law, paragraph 920. Don't forget, this is the Halsey's Laws of England, right? Claims made by the Crown cannot be supported by mere pretense of prerogative. Since the courts have power to determine the extent and legality or otherwise of any alleged prerogative, right? I'm always told the courts can't interfere. They can, right? Nor may illegal acts be rendered justifiable by the plea of the sovereign's commands or state necessity, right? So if they're doing things that are illegal and then they say, but it's by state necessity, they're not allowed to do that. The Crown is bound to observe the law both by statute, and then look what it says again. This is littered with this. The terms of the Coronation Oath, right? So for anyone saying that the Coronation Oath Act isn't valid and they can do what they want, it's an absolute lie, right? So again, I'm just going to bring that up a little bit touch so you can see it, right? Which embodies the contract between the crown and the people upon which the title to the crown originally depended and still in large measure depends. Upon any doubts, points of prerogative for the crown, it's the ministers must therefore bow to the decision of the courts, right? At common law, the crown is not entitled by virtue of the royal prerogative to take possession of a subject's property for reasons of state without paying compensation. However, no person is entitled at common law to receive compensation from the crown in respect to damage to or destruction of property within or without the United Kingdom caused by acts of lawfully done by or on authority of the crown during or in contemplation of the outbreak of a war in which the sovereign was or is engaged, right? But most importantly, I'm going to take you over to another part because I've no doubt many of you are aware of this, right? This is why I say that petitions are massively important, right? Anyone who knows me knows that I have petitioned the Crown, and when they arrested me, I used the English Bill of Rights in the court, and they stood up and said, we offer no evidence because I used it correctly, right? In how I actually presented it to the court, right? So 923 petitions. In cases where no illegal act has been committed and consequently no action lies, but where the subject deems himself unduly oppressed by the sentence of a judge or the conduct of an official, the law of the Constitution has provided a remedy by petition to the Crown. The exercise of this right cannot be denied, since it is the right of the subject to petition the sovereign, and all commitments and prosecutions for so petitioning are illegal. And then it tells you where it comes from. The Bill of Rights, 1688. The necessity for such a provision was proved by the Seven Bishops trial, 1688, right? So why I'm telling you this is because you are being constantly lied to. You are being not just lied to, but misrepresented by barristers and solicitors and the judiciary that do not accept and will not accept because we are under occupation. They are part of the occupation force, the same as the police are. The police are in effect the Red Guard, right? So the only way in which we can claim these rights is to organise and to educate people. So this week, for example, Friday, I'll be at the Thetford Freedom Festival, right? And people need to understand. There's a number of people going to it. Andrew Briston will be there, I believe. Myself talking about the Constitution and our rights. And it is a good festival, and people, if you can get there, get there. If I can bring it up somewhere, I will. But it's currently started to be set up as we speak. But people do need to get that what I'm trying to teach you and tell you is the Constitution of England, right? I am a subject of the realm. I am a paralegal. They won't allow me to speak in court for you, right? Because against restraint of trade and against the monopoly laws of the common law of this country, the legal profession, right, who were once banned from becoming members of parliament for at the minimum of 18 months before they could be a member of parliament, because they knew the law and people knew that they didn't want them in parliament, right? Because if they got into parliament, all they would do was, because of their legal shenanigans would create for themselves a monopoly, and that monopoly is siding with the state, not with the subject. Whereas if you get a subject to the realm like myself, who does know the law, that can present the law from law books, that can take them to the rulings directly and say, this is why we have this. And again, they've referred to A.V. Dicey on a number of occasions. His second book that I've got here, the original, categorically states that there are some laws that can never be revoked by Parliament, because the statesmen that put them in place knew what the word forever meant. Now, if you go back to the American guy that was talking about the juries and the Constitution, they're going back to original. So what does that mean? Is you take the meaning of the time. Well, what is the meaning of in perpetuity? What is the meaning of in this realm for all time to come? What is the meaning of forever? 3 times it says that in the English Bill of Rights. So there's 4 references in the English Bill of Rights to forever, and somehow these people are suggesting that they didn't really mean that. Well, those people that are telling you that they didn't really mean that are the upper middle class, and the people that are suffering the most are the working class of this country. We was given the vote, right? And people not voting, again, the Crown cannot, I want everyone to understand what I'm saying. The Crown must, by law, either assent or dissent from law. It cannot abstain because they are sovereign. So if you are sovereign and believe you are part of that sovereignty, you cannot abstain, right? Because if you do, you give up your sovereignty. You're not claiming your right, and you need to be claiming. The basic form of claiming a right is to vote. Even if you wrote Ashby versus White, 1703, I do not consent. I'm suggesting by the first video I played, which was Rupert Lowe, you've got someone largely that's on your side you can vote for, right? They're not going to be perfect, right? I'm not suggesting in any way that Restore Britain are perfect, and they admit they're not perfect. But most of the people believe we need to act on this. The only way you're going to get it done without violence is to vote. Now, before I go on to anything else, I'm going to show you something else because I think it's important. And again, once I actually find it on the screen, there are 4 elements to this that I want to show you, right? So on the Daddy Dragon website, which I'm going to bring up on the screen now for anyone who wants to see it, there's 4 long blog posts, right? And I'm going to go back to blogging on Daddy Dragon, etc., and start ramping up that website again. The Constitution is the solution. There's me, as you can see, standing there in my St. George's kit. The Fabian Society, the Masters of Subversion. These people are communists, right? And if we ain't careful, we're going to end up in a massive famine because of these people. Now, again, you can see them shaping the world by their books in the way that they want it, against your will. They deliberately conned and again, everyone needs to go and have a look at this, but they deliberately conned the working class, because the people that founded the Labour Party were in effect the Fabian Society that were funded by the Rockefellers, the Rothschilds, and the large pharmaceutical companies and industrialists and bankers, right? And the reason they did that was because the working class was becoming educated and Bolshevik. I don't mean Bolsheviks, I mean Bolshevik. Started to saying, we want these rights, etc. And we started getting there. But before I go any further, I need to find a particular part of this. Hopefully I'll get it. Border. Now, on your screen, I've gone straight to one particular part, right? And that is the UK Border Agency, UKBA, formed in 2008 as the Labour government's border control agency by Fabian Immigration Minister and Progress co-founder Liam Bryan. Now, if you don't know who Liam Bryan MP is, he is currently the MP of Birmingham. Look at the state of Birmingham. He is a Fabian, a former Rothschild banker, who is also co-founder or was co-founder of the Young Fabians magazine, Anticipations, right? Now, what he has done was he has removed, in effect, the Navy from the Channel and put in place Border Force that is a ferry service for migrants. They knew what they was doing and they've implemented that. They also take control of the charities and NGOs, including the INLA, which is why you're seeing lifeboats that you are paying for ferry these people in to port, right? So people need to understand exactly what's going on. And if you go and read all of this, and it is a long read, but people do need to understand that it's not, there is nothing in there. If I can find the element where it says they created the, let me see if I can find it. Edit, find, right, Independent Labour Party. Let's see if it's come up anywhere. 1 of 5, right? So, having indoctrinated the massive with Fabian ideas, this is on your screen now. The next phrase was organising them, and a key step in this direction was the formation of the Independent Labour Party, right? This is what the Fabians did. Go to the next one. The Independent Labour Party was founded at a Fabian conference in 1893 through the merging of over 70 local Fabian societies and was headed by Fabian Keir Hardie, a Scot, right, who had earlier co-founded the Second International with Frederick Engels, a known communist, right, who wrote the Communist Manifesto, co-wrote it. It was Frederick Engels that wrote that every communist revolution had been shipwrecked on the Rock of England. Once the new organisation had been formed, the society spared no effort to increase its influence in branches of the Independent Labour Party and the Social Democratic Federation. So remember what Southern Ireland is, Social Democrat, all over the country. Tellingly, as in other matters, it modelled itself on the Milner Group, British South Africa company, comparing the Fabian Society's control over the British people with that of the BSAC, control over South African natives. Right, and then again, for example, in 1897, the Fabian executive announced that, like the chartered company in Africa, the Fabian Society will capture and control the British natives for its profit and their own good. Fabian News, September 1897, quoted by Pew, page 58, right? None of this is a game, people. And again, all I'm doing is showing you this has been a long-term conspiracy against England, right? Once you understand it is an attack on England, the Independent Labour Party's aim of controlling the working classes for Fabian purposes is also evident from Beatrice Webb's diary and other Fabian documents. By 1913, she was able to observe that the Fabian Society and the Independent Labour Party were well on the way to controlling the policy of Britain's Labour and socialist movement. The above demonstrates beyond reasonable doubt that socialism, including Fabianism, has been imposed on the working classes by outside interests. This fact was openly admitted by Lenin, who used it to suppress all spontaneity in working class movement and bring it under the control of his own social democratic, later Communist Party. See Lenin, what is to be done, right? In other parts of ordinary Labour supporters were aware of the Fabian activities, thought of them as unprincipled spiders, spinning webs to entrap honest socialists. So people like me that are for the working class, but we don't believe in any of this communist nonsense, right? In one of his more lucid moments, Bernard Shaw concurred, referring to himself and the society as magnificent parasites. All right? So it goes on further. Do you want me to carry on reading this out to you? The Fabian Society and the Labour Party. Another Fabian instrument for entrapping the unsuspecting masses was the Labour Party, set up in 1900 by Keir Hardie, slip of the tongue, and fellow socialists. The party was well known as the Labour Representation Committee for the first few years of existence, right? People don't really. So the same thing has happened with the Fabian Society. It's called the International Fabian Society. In America, they have took control of the Democratic Party in America. And Trump knows that, right? Eric Trump talks about the Fabian Society, right? So again, that it is not representing Labour is evident from the middle-class Fabians involved in its formation, who included Bernard Shaw, Sidney Webb, and Edward R. Peace. From inception, Peace was one of the Fabian Society founders, sat on the Labour Party executive, followed by Sidney Webb and others. The Fabian Society currently describes itself as a think tank. However, as a think tank operating within the Labour Party, the society is, by definition, a body of experts. We all know we can trust experts, of providing advice and ideas on specific issues which are then implemented as Labour Party policy. Indeed, from inception, the Fabian executive described Fabians as the brain workers of the Labour Party, right? April 1918. In 1950s, Fabian Secretary Margaret Cole described the society as the thinking machine of the British socialism. The society continues to define itself as being at the forefront of the developing ideas in public policy on the left, right? And again, there's lots of stuff on here. There's one particular bit I want to get to because people need to understand where it's coming from. So what I'm going to do is hopefully show you it. There's so much to this. People do need to go and read this. I've read it out a number of probably tomorrow night. I may, if I've got time. Let me see if I can go on to that. Find what we're looking for. Attlee. There, right? So, and again, do you all understand how they've destroyed our steel industry? And I'm going to ask Janet something in a couple of seconds about her granddad. The Fabian Society and the Tata Group, one of the Fabians linked to the industrial interest was the Indian textile magnate Jamsetji Tata, whom Sidney and Beatrice Webb helped to set up a company town around his newly acquired steelworks at Bombay, where the Fabians had set up a local Fabian Society. In 1912, Tata Downants funded the Sir Ratan Tata Department at the London School of Economics, which later became the Department of Social Sciences, whose first lecturer was Fabian Society member and later New Fabian Research Bureau chairman Clement Attlee. He also became, as well known now, the Prime Minister of the UK, right? So again, referring back to Janet, we was talking about this and I was reading parts of it out. What did you say your granddad said? And bearing in mind, how old was your granddad?
My at the time when he said it, probably would have been in his 50s, getting on 60. I was really little, but I can remember him having a conversation with someone.
Right.
And the man said to him, "How comes you've always voted Conservative when you're a working class man. And he said, Labour ain't for the working class, they're tricking everyone.
Right. And again, that's exactly what my granddad used to say as well. So it's funny that there are working class people with independent and critical thinkers that understand that it is the middle class and particularly the upper middle class. So don't think when I'm having a go at the middle class, engineers, there are groups of people that are university educated that I would describe as blue collar workers, right? We're not talking about them. We're talking about the upper middle class, and they are directly associated with financiers, banking, pharmaceuticals, academia, and what they're doing is using their influence at a higher level within our society, right? So again, I just want to make sure everyone understands that. I'm going to put that out there again in the link to this. If you want to do some proper homework, I would suggest people read through this. It gives you so much. If people actually understood who and what the Labour Party are and still are, no one in this country would vote for them. No, there ain't a single working class man. People up north need to know that they have been conned in a big way, right? And I understand why it's happened. The other thing is the Society and Roundtree. So you know Roundtree, the Fabians, Castle interests, and it goes through Rockefeller. Talks about Rockefeller in it. Again, mentions Rockefeller's Council on Foreign Relations, operating within the US State Department, was responsible for designing America's post-war foreign policy. A key element of this policy was the 13 billion Marshall aid that funded Europe's socialist governments, including Britain's own Fabian Socialist Labour government run by Prime Minister Clement Attlee, former chairman of the new Fabian Research Bureau, right? And again, if you understand this, you'll understand something else, which I'm about to bring up on the screen. Someone I've spoken about a lot, which is, let's do 2 Peters. A guy there, you can see his name: India, Rothschild, Shell, Barclays, Goldman Sachs, JP Morgan, Morgan Stanley are members of the London School of Economics Careers Patron Group. Peter Sutherland, who is the Irish guy, was chairman of the Goldman Sachs International and is chairman of the London School, or was chairman of the London School of Economics. When I say was, he's dead. But Peter Sutherland was also the Irish guy that was responsible for the United Nations migration of all of these migrants into Europe, and he particularly wanted to destroy England, right? So again, all of this information is out there. Like Pearson, Lazard is left-wing. Lazard is a bank. Left-wing operation with a long history of support for left-wing causes. It has been a supporter of America's Democratic President Barack Obama and has hired leading Fabian socialist Peter Mandelson as a senior advisor. So Lazard, the bank, directly employed Peter Mandelson. So they know what's going on. And then Fabian control over the working classes. I'll finish on this. The monopolistic elements in liberal capitalism had been able to secure control over resources, oil, gold, and steel, with the collaboration of the ruling upper middle classes, whom they were gradually replacing. However, the emergence of a less malleable new class of industrial workers was threatening to disrupt the established balance of power in industrial societies. So this was a deliberate attempt to destroy the working class, particularly of England and of America. And President Trump knows that, by the way. there's certain things he's put in place, which I don't want to go into tonight. So do you all understand exactly what's gone on? Have I, hopefully you've enjoyed tonight's show. Some parts of it was literally going through, hopefully. Carnegie or Carnegie?
Carnegie.
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 We've had this all weekend, people.
Why do they make these things so difficult? Right, so Rothschild, the Carnegie geezer, Rockefeller, right, all part of it. Let me have a look. Labour under control of the IRS as well. Let me education as well. Thank you very much. So if you've enjoyed this, hit the like button, hit the subscribe button, and above all else, share, right? Because people need to understand what's going on. And don't forget, this Friday, I will be at the Thetford Freedom Festival. I'm seeing if I can find it somewhere on my screen to bring it up. Let me have a look. I did actually send it to someone the other day. What I don't want to do is show anything a bit strange out there, or anything that's not part of what I should be showing you. Let's have a look. Is that the one? There it is. Why should you attend? It is the Thetford Truth and Freedom Festival. So the Thetford Truth and Freedom Festival, guest speakers on one of them, camping, live music, evenings, families welcome, real ale, food, coffees, etc. Street food, evenings, product stalls. And let's have a look here. Let's see if they've got anyone coming up there. And the venue is the Angel Inn, Larlin, Norwich, NR, November Romeo 162, Quebec uniform, right? And it's 2 days, Friday the 17th and Saturday the 18th of July. So we've got to try and get up there as early as possible on Friday. I don't even know what time it starts. It looks like it starts from 10 a.m. Yeah, I'll have to speak to him to see how early he wants me up there. Tickets, £20 available from the Fatsuma app. But it's out there, and it's going to be a good event, right? Let's see if I can bring it up and show you.
You can pay on the day as well. You ain't got to have tickets. You can pay on the door as well.
You can pay on the door, yeah. Just to let you know. Right, let me have a look and see if I can show you this without it going pear-shaped. Let's see if I can show you the WhatsApp thing. Right, there it is on the screen as we speak, right? So I'm going to bring that down. Come down a bit, that's it. So there it is, right? So you're now seeing what it is. The Thetford Truth and Freedom Festival, guest speakers, camping, live music, evenings, families welcome, real ale, food, coffees, etc. Street food, evenings. It's gone pear-shaped on me. But there it is on the screen. That's it, right? I'll show it again tomorrow night. Anyone else? Any questions from anyone? Let's have a quick look and see if I can see any questions. Let's have a look. All right, it's on our website as well. So if you want to go and have a look at our website, you can. Thetford, the Truth and Freedom Festival, July 26th. Tickets now on sale. It's all on there. So if you want to go along to that, we'll be talking. There's a few people who's going to be there, myself and others. It should be an interesting weekend because all you're going to get is the truth. Adjective, start small and only refer to imperial measurements and Fahrenheit. Good night. God bless everyone. Thanks for no worries. Don't forget, everyone, what I believe in. The Constitution is the solution. America's taken their country back. We need to do the same thing. All right. So let's make sure that's on there. So I'm going to bring that back up, take that back onto my live chat, and I'm going to be off. Oh, it's not worked. Oh, there we go.